it could definitely have raised that we established it. We were administering it. We are a minority now post-constitution. Because before that constitution, there was no minority concepts. There were, all of us were subjects, Hindus, Muslims, Parsis, Sikhs, Jains, everyone. Now, we have been doing it. That's what, my lord, the Saint Stephen did. Saint Stephen did that, my lord.
And right, now we have seen this note on administration.
Now please
what
see,
is the next point?
Post-constitution, my lord, I have given the chart.
Which is that chart?
Lord, page 5. Page 5. Post-constitution, after taking into consideration all amendments, Lord, as it stands today, as AMU stands today, is there any administrative control? Because your lordships, it is not disputed that word "and" will have to be read as "and" only. Established and administered, not "or." It's not their argument also. Now, Lord Chancellor need not be a Muslim under the new act. If de facto governor appoints him, doesn't make the legal difference. Lord, kindly see, my lord.
How many chancellors have been non-Muslims actually in the case of the institute?
We have not examined, my lord, but possibly all were Muslims. That's the convention. I am on law. 23 or 25 so far. So, my lord, de facto status would not change the legal position. My lord, for example, Lord, suppose there had never been a lady attorney general. That doesn't mean that it has to be a man. It incidentally happened to be a man.
That argument may be slightly different. That argument.
But I'm giving the example may be different.
That would be a correct argument.
Lord, example may be a different, my lord. Example,
but when we are examining whether what has been the history in the past, whether administration can be only judged on the basis of what has happened and what has been actually after in last, how many, 1920 till we almost now going to be completing 100 years in another 3 years?
103 years, yes.
103 years.
I just answer that question.
Any time in the past where the chancellor, pro-vice chancellor, vice chancellor have been non-Muslims?
I'll check up and say, but not to my knowledge. Possibly they were Muslims.
And why is it then that governments, both before the advent of the constitution...
I'm told 4 were non-Muslims, my lord. 4 were non-Muslims.
But why is it that before the advent of the constitution and post the constitution, the predominant choice of chancellors by successive governments has been of Muslims? That's certainly one factor which has to be borne in mind.
By government appointing a particular community, though the law does not require it to do, change the character of that university, that the government keep on appointing Muslims. Irrespective of Article 30, it's not established or administered.
As you rightly said, that we have to look at it in a holistic perspective.
Yes.
Could it possibly be a recognition of the fact by successive governments that this is how they have been perceived at an administrative level by the university itself?
Then they would not have required 81 amendment. If that was the interpretation, that is how it was being given, I'll come to, my lord, the periodical interpretation. Why I say, my lord, it need not be a Muslim, there is a reason. Your lordships have seen the provision of court, where there was a provision that all members shall have to be Muslim. That's the legal provision your lordship would bear in mind. Here it doesn't say the chancellor will have to be Muslim. Incidentally, he was a Muslim, he or she, is different thing. That would not change your lordship's, my lord, adjudication whether this has a minority status or not.
There's one more thing. Suppose, let's assume it's a minority institution.
Yes.
In a case. The minority institution appoints a non-minority as the vice chancellor or chancellor. Will it make it non-minority?
It cannot. Lord, Saint Stephen's, reverse, your lordships are right. Saint Stephen's do not always appoint, my lord, principal from the Christian community.
Really speaking, therefore, when we look at the term administration, we'll have to take into account how actually it is administered on the ground.
The legal position, not de facto position. The legal position. My lord, in case of St. Stephen's, my lord, it is never that only Christians were appointed as principals. Then it's bad. That's not the concept of a minority institution. But Lord, my point is, your lordships will go by the statutory provisions.
Because our law recognizes the power of the minority to appoint the head of the institution. No outsider can be foisted. You may choose somebody else. You may have a distinguished nuclear scientist who is not a minority.
Ideally not.
Choice. The element is
I'm not saying
the
legally
element
wrong.
is the choice.
I'm not saying legally wrong. You should not confine the benefit going to the students to one community. There may be many other eminent people, may not be belonging to a particular community, who can take the institute to a further height. But you can't deprive the students of that. That's what as an ideal position, not legally, it is wrong.
Okay. Article 30 in the end uses the word choice. If by choice a minority institution agrees to abide by certain terms and conditions in order to establish itself and get certain, say, a degree, will they lose that by choice if they do it? Will they lose their minority status?
It is a minority.
It is a minority institution.
Undisputed minority.
Yes. By choice, they agree to certain rules and regulations and even administrative overall supervisory control. Will they lose their minority status?
Not after the constitution. If it is established after the constitution, no. My lord, for example, take a flip side.
Why
take a flip side, my lord.
Once you accept that, then why not before the constitution?
Lord,
because once you accept, then the administration is with them.
My lord, take a flip side of it. My lord, suppose in Banaras Hindu University, as a tradition of a gesture of goodwill, the government continued, had continued. I'm giving a hypothetical example. Only Muslims are vice chancellors and Muslims in the position of power. Would it come, and I'm posing a question to myself, would it convert itself into a minority institution? If what example we are discussing is true, the reverse also has to be true. If de facto can change the de jure position, then my lord, it should apply to everyone. And my lord, there are some benefits to a minority institution. From tomorrow onwards, my lord, some institution can start converting itself into a minority by merely appointing people. Though law does not require, the statute incorporating it may not require. All British, my understanding is right, all British authorities were Christians in those days. So, my lord, de facto, what is the position is, in my respectful submission, irrelevant. It may be a practice, it may be a political stand of the government, it may be, my lord, for various reasons, as my lord, in the initial Britishers also were requested that please, izzat ke liye, but that's the word which is used. Take into account our feelings and have Muslims. Maybe that's the reason. But that doesn't define the character of the institution. But therefore, I say, the way court mandates only consisting of Muslims with the provision now.
Let's quickly run through this chart so that we can go on to the next.
Here, when I say need not be Muslim means the law doesn't require him to be Muslim. He may be Muslim, he may be any other religion. Chancellor need not be Muslim, pro-chancellor need not be Muslim. Throughout, I'm not reading it, up to proctor need not be Muslim. Then representatives of the department and colleges need not be Muslim. Some expert, my lord, in a chemical engineering branch may be sent as a member, my lord. He may not be Muslim. He may happen to be a Muslim. But the law doesn't say that a representative of department of colleges belonging to Muslim community. That's not the law. Need, therefore, my lord, I am carefully using the word need not be Muslim.
Okay, this the chart in Annexure A is pre-1981 or post-1981?
As on date, as it stands.
And what is the position pre-81?
Lord, I have said, Lord, court is concerned, it was full Muslims. Till 51 amendment, it was deleted. 1951 amendment which was deleted. I'll show Malord that comparative.
So this is as it exists
as
today.
it exists today. And as it exists today, Malord, if your lordships were to go, need not be Muslim. Malord, when I say Malord, representative.
There may be slight problem in this because we have to deal with the whether it's an institution which was minority or not as on the date when the constitution.
Correct. This is irrelevant according to my submission.
So this 1981 amendment may not be so much, or post 1981
Yes.
may not be so much, because if it was a minor, you can, to that extent, there is no list between the two sides. If it was a minority institution as on the date in 1950, then it will continue to be a minority institution.
Malord, the difficult.
Because they have challenged, some of them have challenged the 1981 amendment also.
Yes, that's the issue. That I'll come to that, Malord. And there, when the bill was introduced, it was introduced on the ground that Congress had that in the election manifesto.
That was
the ground. And there is a beautiful opposition by an eminent parliamentarian who was an eminent counsel of this court, Somnath Chatterjee, that you can't do this. This is not the way you take away basis of the judgment. I'll come to that. But, Malord, there are only 35 persons who can be Muslims out of 189 as on date. Who can be Muslims, for what I'm saying. Mandate, no mandate that they have to be Muslims. For example, representatives of alumni, past alumni. But there are all community students who are studying here. They have engineering college, management college, medical college, everything. Maybe other community people may represent that constituency of alumni. Two persons representing Urdu language, for example. He may not be a Muslim, but an expert in Urdu. There are people who are experts in Urdu. They can, be the representatives. So, therefore, I carefully use the word need not be Muslim. The law doesn't require them to be Muslim. But 39, 35 people, 37 people may be Muslim. I am against, they also don't require Muslim. Please, Malord, come to page 8.
What is the reason to bring in representatives of Muslim culture and learning?
There is one of the subjects. The way, Malord, other subjects are taught.
Why do they at all have to bring in people who are representatives of Muslim culture and learning? Or what is the need to bring in, say, representatives of the All India Muslim Education Conference? What is the genesis of that?
Malord, if your lordship sees, there are several subjects being taught. Lord, there is, Malord, a separate constituency, representatives of teachers other than chairman and department and principals of colleges. So they have representation. Chemistry will have a representation, medicine, biology, etc., etc. But one of the subjects out of several is Muslim theology and Muslim culture. Therefore, they have representation. But therefore, it does not say, the provision does not say they will be Muslims. Muslim Cultural Association will send 5 people. They may be Muslims. They may send others also. Look, therefore, I say what is required as per Kerala Education Bill is sprinkling of outsiders. This is not sprinkling of outsiders. This is predominant outsiders. If I may use that expression, nobody is an outsider, but predominant non-minority people. Yes, I'll now, my lord, come to, Lord, I'll just show the chart, my lord. My lord, the Chief Justice also, my lord, desired that there has to be on one page how the amendment took place. My lord, first in 51, 65, 72, 81. So we have prepared that chart. It won't take more than 5 minutes because we have depicted the amendment in different colors. So your lordship would get only in 5-7 minutes. My lord. The amendments.
Section 9 was amended in 51 or 59? Section 9, that
50.
amendment, 51.
50. My lord, your lordships may see the legend on the top. Black is original act, my lord, as it stood. I'm sorry, my lord. What is in black is as it stood when the act was passed. red is 51 amendment, orange is 65 amendment, gold is 1972 amendment, and green is 81 amendment.
All right.
Lord, the relevant would be, my Lord, kindly see the green one, my Lord, first, in 1981. An act to establish and incorporate a teaching, established and is deleted. My Lord, with limited experience, my Lord, I have come to know about such an amendment for the first time, where the preamble is amended, that it was not established. The historical fact is changed by making an amendment after about 60 years. And incorporation continues. So incorporation is also establishment. They possibly forgot, my Lord. That established and incorporated. Now, please, my Lord, see.
No, there may be an alternate reading also, which is that the amendment to the preamble is to bring the preamble in conformity with a historical fact. And in that sense, it is declarative.
Historical fact, my Lord, cannot be changed, my Lord, by...
They're not changing a historical fact. They're changing the provision of an act which was inconsistent with the historical fact. So as to bring it in conformity with the historical fact.
Lord,
I mean, there's an alternate reading possible.
Lord, kindly appreciate...
One more thing. This is the amendment by the parliament.
Correct?
And is the government accepting the amendment or?
I'm not.
How can you not accept it, accept an amendment by parliament? Mr. Solicitor, parliament is an eternal, indestructible body under the Indian Union.
Correct, my Lord, and
And
continuing.
irrespective of which government represents the cause of the Union of
No,
India.
I'm not saying.
Parliament's cause is eternal, indivisible, and indestructible. And we can't hear the government of India to say that an amendment which Parliament made is something I don't stand by. You have to stand by this amendment.
Allow me to answer that, my Lord.
You have an option. You go
Allow
through
me
the
to
amending.
answer.
You have an option. Go through the amending route and change the amending act
Allow me
again.
to answer that question.
That's ultimate power.
My Lord, allow me to answer that question. My Lord, I am not arguing a matter of A versus B. I am before a 7-judge constitution bench answering constitutional questions. That is number one. Number two, the amendment in question was subjected to challenge before the High Court, and there is a judgment declaring that it is unconstitutional for ABCD grounds. And as a law officer, it is my right as well as my Lord, entitlement and duty to say that this view appears to be correct. And third,
Mr. Solicitor, this will be radical, because a law officer will be then telling us that I don't abide by what Parliament has done.
my Lord, in that case,
You have to stand by what Parliament has done, but Parliament is supreme. Parliament is undoubtedly supreme in its lawmaking function. Parliament can always amend a statute. In which case, the law officer can say, "Well, I have an amended statute now, which I am going to place
your
before you."
lordships expect.
Can we hear any organ of the union government to say that, notwithstanding a parliamentary amendment, I don't accept this amendment?
Lord, I am supporting the judgment. Lord, would your lordships, my Lord,
In that sense, Parliament.
please allow me to answer this.
Parliament is, that's why I said, Parliament is an eternal, indivisible, and an indestructible entity under the democracy.
No, I am not disputing that, but my Lord, I'm posing a question to myself.
How can you
Would
say, look, I don't accept the validity of an amendment? Or I don't accept that there was a ground for this amendment?
Can I answer? It's more, my Lord, one-sided there, my Lord. Can I answer that? Would a law officer be expected to say that whatever amendments were made in the Constitution of India during emergency were true only because they were made by the Parliament? Here, I have a judgment of the Supreme.
But Mr. Solicitor,
allow me to complete.
That's why the 44th
I
amendment
will not
came
raise
in.
that point, my Lord.
That's why the 44th amendment.
Let others
came
argue, my Lord. If that is so, my Lord, I will not raise that.
If the 44th amendment came in only for that, the 44th amendment came to redress the evils which were perpetrated in the name of a constitutional
Who
amendment.
will decide, my Lord, that these are evils being perpetrated?
Obviously, exactly. You prove my point. The power to decide that is in the elected body of the people, which is Parliament.
My Lord, there is...
Parliament can always say that what we did during the emergency was wrong, and we are rectifying it by the 44th
Not
amendment.
after it is set aside by the division bench of a High Court my lord, and therefore it is not on the statute book. And when I am not in A versus B situation, I am in a constitution bench answering a legal proposition, whether such a thing can be done or not. And if I do not do, and there is an affidavit filed by the government, it's not my stand, it could have been my stand also. But if I cannot argue, my lord, that this amendment could not have been made, I will have to support, any law officer will have to support every amendment made during emergency, irrespective of, my lord, whether it is my view or anybody else's view that this was to remove some anomalies or some bad things happening to the citizens of India. I'm sorry, please don't make it a political thing. Please don't do this. Then don't interrupt. Then don't do it. Then don't. You say don't. I don't want to interrupt, and then you interrupt.
Ability in court, please.
My lord, I am sorry, my lord. Your lordships would come in. Your lordships would come in.
Let's not,
argument.
Your lordships would come in, my lord.
Let's 1 second.
No, my lord.
One second, Mr. Let's not allow the pristine character of the dialogue to degenerate.
Yes, my lord. This is unacceptable.
1 second. We give you 30 seconds to make a point of law, not on personally on the Solicitor General. Let's keep out personal. Yes, just 30 seconds.
On the day when the emergency argument was, I was only going to make a historical reference, Mullah. I was sitting in court when the Attorney General of India, Nirande, was standing here and arguing that what has been done is right. I defend the emergency provision. Why? Because he could not say otherwise. It's only that I'm saying. But I was not going to say anything against him.
Yes.
I don't know why. But
no, my lord, you did say something. You used an uncivilized word which is not used in the court, and you generally do not use. Maybe infected as of now, but my lord, I'll say, your lordship, the distinction is Nirende was not, my lord, in a situation where one high court had struck it down and the provision was not on the statute book.
Yes,
Here,
Madhya Pradesh High Court had struck it down.
9 high courts.
Yes. What do you?
there were other high courts which have upheld, and there is all your lordships are aware, Mr. Nirende told the court that if somebody is hanged, can we not do anything? Yes, he said, yes, we cannot do anything. It was not to defend it. It was to instigate the judges that please interfere. This is the position. Lord, everyone knows, my lord, there are two versions. When Mr. Nirende, the learned Attorney General, then told the court, when the court asked, do we not protect Article 21 if somebody is being hanged or his personal liberty is deprived? He said, yes, you cannot do it. It was not to defend the act. It was to instigate the court that this is the position. Please interfere.
Mr. Solicitor General, let's come back to the